If this is your first time here and would like to see more videos like this, consider subscribing and clicking the bell so you don't miss anything.
United States District Court, Middle District of Florida, Orlando Division. Rare Breed Triggers, LLC and Kevin C. Maxwell. Plaintiffs: V. Merrick Garland, Craig Sayer, Marvin Richardson, U.S. Department of Justice, Bureau of Alcohol, Tobacco, Firearms and Explosives, Earl Griffith, and David Smith. Defendants order this causes before the court on plaintiff's emergency motion for a preliminary injunction motion, Doc 2, to which defendants 1 filed a response in opposition, Doc 37. After hearing, minimum, entry, Doc 63. For the reasons stated herein, the motion will be denied. 1. The response was filed by the agencies of the United States and federal officers sued in their official capacities. Background: this case arises from a cease and desist letter, A.T.F. letter, Doc 26, issued to plaintiffs by the U.S. Department of Justice, Bureau of Alcohol, Tobacco, Firearms and Explosives, A.T.F., requiring that plaintiffs Rare Breed Triggers, LLC, Rare Breed, and Kevin Maxwell, C. Ease and desist all manufacture and transfer of the Rare Breed Trigger FRT-15, which, per the A.T.F.'s letter, is a combination of parts designed and intended for use in converting a weapon into a machine gun. Ida 2. The A.T.F. letter, which was issued on July 26, 2021, advises that plaintiffs' failure to comply with the requirements of the letter may result in 1. Law enforcement action by A.T.F., including a referral of this matter to the United States Attorney's Office for Criminal Prosecution. 2. Tax assessment and collection, and/or 3. Seizure and forfeiture of the firearms and property involved in violations of federal law. Id. Plaintiff's amended complaint, Doc 32, alleges 5 counts, 3 counts for violation of the Administrative Procedure Act APA, 5 U.S.C. Section 702, 704, a Bivens claim against the individual federal officer defendants, and a claim for writ of mandamus, Ida 26-48. Plaintiffs have filed the instant motion, requesting that the court restrain defendants from taking the steps outlined in the A.T.F. letter. 2. See generally Doc 2. 2. Legal standard to obtain a preliminary injunction. The movement must sufficiently establish that 1. It has a substantial likelihood of success on the merits. 2. Irreparable injury will be suffered unless the injunction issues. 3. The threatened injury to the movement outweighs whatever damage the proposed injunction may cause the opposing party. And 4. If issued, the injunction would not be adverse to the public interest. Forsyth TV, U.S. Army Corps of Engineers, 633 F. 3D 1032, 1039, 11th SIR 2011. Quoting Siegel v. Lepore, 234 F. 3D 1163, 1176, 11th SIR 2000, and Bong. A preliminary injunction, moreover, is an extraordinary and drastic remedy not to be granted unless the movement clearly establishes the burden of persuasion as to the 4 requisites. Yovera v. Flaw, 576 F. Apps 894, 896, 11th SIR 2014, per curiam. Quoting Forsyth T. 633 F. 3D at 1039. 3. Analysis: plaintiffs must demonstrate that they have satisfied their burden as to all 4 preliminary injunction elements. Id. Henry v. Nadelhouse P. Ship, No. 106 CV008 SPM, 2006 U.S. Dist. Lexus 104140, at 6N. 1, ND. Flaw September 19, 2006, whereto the court previously denied plaintiff's emergency motion for an ex parte temporary restraining order. Doc 3, August 5, 2021 order. A plaintiff has not carried his burden as to any one of the elements required for a preliminary injunction. It is unnecessary to address the remaining elements. Citing United States v. Jefferson T. 720 F. 2D 1511, 1519, 11th SIR 1983. A showing of irreparable injury is the sine qua non of injunctive relief. Hoop Culture, Inc. v. Gap Inc. 648 F. Apps 981, 984, 11th SIR 2016. Citing Siegel, 234 F. 3D at 1176. That is, the absence of a showing of irreparable injury would, standing alone, make preliminary injunctive relief improper. I'd citing Siegel, 234 F. 3D at 1176. Therefore, the court begins with this element. Plaintiffs first argue that they will be irreparably harmed if the A.T.F is permitted to seize the FRT-15 triggers already in the hands of consumers because customers will lose the monetary value of their possessions and all future customers will be deprived of the ability to purchase and use the FRT-15. Doc 2-22. Additionally, such customers will then inevitably seek chargebacks against the company when that property is seized, which will cause unrecoverable financial ruin to the company. See also stating that assets of the plaintiffs will be seized, causing Rare Breed's business to collapse and cutting off Maxwell's income and his ability to provide for himself and his family. Plaintiffs' only evidence supporting the contention that Rare Breed will suffer unrecoverable financial ruin and Maxwell will be unable to provide for himself and his family. Doc 2-22 is Maxwell's affidavit. Doc 2-1. Maxwell's affidavit summarily states that the A.T.F seizure of the FRT-15 triggers from customers will cause irreparable financial harm to Rare Breed and will cut off Maxwell's personal income and seriously affect his ability to provide for himself and his family. 10. However, Maxwell provides no factual support for the conclusory statements in his affidavit. For example, he has not explained how, as a licensed attorney, loss of his income from Rare Breed for the period of time of this litigation will cause him to be unable to support himself or his family. Absent supporting factual evidence, the court may disregard the conclusory statements in the affidavit. Rogers v. Evans, 792 F. 2D 1052, 1065 N. 9. 11th Sir 1986. Holding that the district court properly struck an affidavit that was phrased in conclusory terms without citing facts. Absent any other evidence, plaintiffs have not demonstrated that the injuries alleged cannot be remedied through monetary relief. Neflaw Ch. of Asnov General Contractors v. Jacksonville, 896 F. 2D 1283, 1285, 11th Sir 1990. An injury is irreparable only if it cannot be undone through monetary remedies. Mere injuries, however substantial, in terms of money are not enough. Plaintiffs next argue that they will be forced to disclose confidential customer lists or risk felony prosecution and that Maxwell, who is a practicing attorney, is at risk of suspension of his legal license due to criminal prosecution. Doc 2-22. As explained in the court's T.R.O. order, plaintiffs have failed to explain why this court has the authority to temporarily restrain a law enforcement action or criminal prosecution by an executive branch agency. Doc 12-3. Indeed, upon careful review, this court is unsure that such authority exists, and even if it does, the court would decline to issue a preliminary injunction in recognition of principles of equity. The court's discussion of this legal authority was included in its T.R.O. order and is incorporated by reference into this order. See IDA 3-5. Plaintiffs have not provided any argument or legal authority that would change the previous analysis. W. Here plaintiffs seek primarily to have the court enjoin law enforcement action by the A.T.F. leading to the potential criminal prosecution of plaintiffs. The resulting consequences from any such criminal prosecution cannot constitute irreparable harm. IDA 5 citing Boyd v. Georgia, 512 F. Apps 915, 918, 11th Sir 2013.3. At the preliminary injunction hearing, plaintiffs made one additional argument regarding irreparable harm that was not contained in their motion. Plaintiffs argued that Rare Breed has filed a lawsuit in the U.S. District Court, Northern District of Florida, against a competing company that is allegedly infringing upon Rare Breed's patent for the FRT-15 trigger. From what the court 3 this principle similarly applies to Maxwell's argument that he is at risk of suspension of his legal license due to criminal prosecution because that is a consequence only encompassed within a potential criminal prosecution. The court takes judicial notice of the case of Rare Breed Triggers, LLC v. Big Daddy Enterprises, Inc., case number 121 CV 149 RHGRJ, filed on September 15, 2021, in the U.S. District Court, Northern District of Florida. See United States v. Jones, 29 F. 3D 1549, 1553, 11th Sir 1994. Can discern from the argument at the hearing, plaintiffs contend that they may not be able to successfully prosecute their patent infringement case if the A.T.F letter is allowed to be enforced. However, Plaintiffs have provided no legal authority supporting the proposition that the potential success or failure of an argument in another legal proceeding, filed after this case and the instant motion, constitutes irreparable harm here. Moreover, plaintiffs have not explained why such purported harm could not be remedied by monetary damages. On one final note, as the court pointed out in the T.R.O. order, plaintiffs have also not demonstrated that any of the alleged harm is imminent. See Doc 12 at 5-6. While plaintiffs presented evidence at the hearing that at least one of the FRT-15 triggers has been seized by the A.T.F., indicating that the A.T.F. may be taking some enforcement action, plaintiffs have still not indicated whether they have chosen not to comply with the actions required in the A.T.F. letter. If plaintiffs have chosen not to comply and any of the consequences in the A.T.F. letter have come to fruition, the court is not privy to those actions because plaintiffs have not presented any evidence of such. As far as the court is aware, the status quo has been, and can continue to be, preserved by plaintiffs' own actions of working with the A.T.F. to develop a plan, Doc 26 at 2, requiring plaintiffs to cease and desist manufacture and transfer of. It is recognized that a court may take judicial notice of a document filed in another court not for the truth of the matters asserted in the other litigation, but rather to establish the fact of such litigation and related filings. The FRT-15 trigger and 2. C. Contact A.T.F. within 5 days of receipt of E. letter to develop a plan for addressing those machinagans already distributed. Plaintiffs have not demonstrated irreparable harm. Therefore, the court need not consider the remaining elements, and the motion will be denied. IV. Conclusion. In accordance with the foregoing, plaintiff's emergency motion for a preliminary injunction Doc 2 is denied. Done and ordered in Orlando, Florida on October 12, 2021.
Thanks for watching, and please consider subscribing by clicking on the bell. Also, let us know what content you would like to see in future videos.